Hello, and welcome back to Constitutional Fraud. I'm your host, William Toppi. In this episode, CPCS Investigation Part 1, we'll unveil a story that's as shocking as it is revealing. It's a tale of betrayal, deceit, and an unwavering fight for the truth, all set against the backdrop of a flawed criminal justice system. From perjury to fraudulent actions, nothing is as it seems. This is more than my story. It's a testament to how easily anyone can fall victim to a legal labyrinth laden with treachery. Let's unravel the layers of constitutional fraud, because the pursuit of truth begins now. Follow along as we uncover shocking revelations, exposing a system that perpetually instills fear and vulnerability into the lives of its citizens. With the truth laid bare, this scathing expose invites you to join the fight for justice reform within the Massachusetts justice system. In today's installment, we'll embark on a deep dive into the pivotal investigation conducted by the Massachusetts Committee for Public Counsel Services, CPCS, concerning the conduct of my specially appointed counsel, Debra DeWitt. Together we'll scrutinize their findings, revealing a stark truth. DeWitt's actions constituted perjury and a deliberate fraud upon the court, actions that cannot be denied. Equally indisputable is the use of deception by Judge David Ricciardone in securing the waiver of constitutional rights, an act that defied both the law and judicial ethics. These revelations are nothing short of blatant and profound. Let's delve deeper into this intricate web of legal anomalies. As we explored in our previous episode, I found myself navigating a 2-year probation term for Count 1 breaking and entering, a period marked by my efforts to reintegrate into society. It's crucial to reiterate that this unique and disparate sentence strays from the well-defined boundaries of the Massachusetts sentencing guidelines, which explicitly dictate that a sentence must align with the nature of the underlying charge. This glaring contradiction unveils an undeniable truth. When the judge in open court manipulated the terms and conditions of the plea bargain, a Rule 12 violation, he deceived me by asserting that he was adhering to the guidelines. What's more, this unprecedented sentence left me bewildered, casting a shadow of the very essence of my punishment and the ambiguous nature of the restitution that was yet to be determined, considering that I had already served my full sentence for larceny. However, let's zero in on DeWitt and her role in this convoluted saga. In my quest for answers, I reached out to the CPCS, driven by an innate sense that something terribly awry had transpired. At this point, my understanding of the law was rudimentary at best. I merely sensed that a grave injustice had been perpetrated against me. I had no inkling that Debra DeWitt had filed 3 separate motions, securing $3,500 for investigations that were never conducted. She never bothered to delve into the pivotal facts surrounding my case, like the fact that my co-defendant, Ebby, had exchanged text messages with the victim the night preceding the crime, and that these texts implicated another individual named Chris, who mysteriously materialized at the crime scene during the police investigation and was identified as the victim's best friend. Moreover, the true extent of what transpired in my absence during the lobby conference was still obscured from me. What is evident is that DeWitt signified the intention of a plea even before initiating any meaningful negotiations. The most glaring fact that came to light was DeWitt's admission of a conflict of interest in my case, stemming from an allegation that I kicked a dog during the crime. She cited her personal affront, being a dog owner herself. An even more glaring contradiction emerged. DeWitt informed the court that her client was identified by a Facebook photo unbeknownst to the police. This starkly contradicts her motion to suppress identification evidence, which correctly asserted that it was the police who displayed the witness the Facebook photo from their iPad. These revelations, brought to light after my initial contact with CPCS, paint a picture of unethical, unlawful, and deceitful conduct. It's palpable evidence of perjury and a blatant fraud upon the court. DeWitt's actions in my case form a mosaic of misconduct that's hard to ignore. First, she artificially inflated a false history category level, which effectively amplified the potential punishment. But her misdeeds go far beyond this. She failed to challenge the judge's inappropriate lobbying of the sentence's terms directly with her client in open court. The judge, in this setting, knowingly manipulated the facts and negotiated a sentence with me that flagrantly violated the very sentencing guidelines he claimed to be following. Adding to this web of deceit, DeWitt filed the revise and revoke motion after the sentencing, a motion that disingenuously portrayed as merely a means of preserving my rights, not a request for a sentence revision. The truth is, she knew something was fundamentally wrong with the sentence, which is why she sought the court's correction during the sentencing in the first place. These violations aren't minor oversights or forgivable errors. They are glaring breaches of ethics and law. To the trained eye of an attorney investigating DeWitt's behavior, they're like neon signs of professional misconduct. Normally, one misstep could potentially warrant legal counsel for post-conviction motions and an appeal. But when this many flagrant violations are stacked against the backdrop of this case, they can only be dismissed through one mechanism: the perpetuation of more fraud. There's simply no other way to explain this series of transgressions. On March 28, 2016, I formally requested an investigation into the conduct of attorney Debra DeWitt through the CPCS. My plea for this investigation was swiftly acknowledged by Joan Stone. The summary of my complaint was unambiguous: an out-of-county complaint to Suffolk County, given that DeWitt was a board member of Middlesex County. Aviva Jeruchim, a supervising attorney, was assigned to carry out this investigation. The complaint was tagged as C6231 and it was logged on April 4th, 2016. However, the consequences of my quest for justice were immediate. In less than a week after contacting CPCS for an investigation, I found myself summoned to court by my probation officer, Chris Bowen. I appeared in Lowell Superior Court on April 4th, 2016, facing the grim reality of non-compliance with the terms of my probation. This placed me under the looming threat of being sent back to prison. In this episode, it becomes glaringly evident that the first attorney assigned to investigate DeWitt's conduct was no ordinary practitioner. To provide context, not only was she a board member of CPCS, but she also had a position on the board of the Massachusetts Association of Criminal Defense Lawyers. MACDL's mission statement explicitly emphasizes the preservation of the adversary system of justice, the cultivation of independent and skilled criminal defense lawyers, and the unwavering commitment to ensuring justice and due process for individuals accused of crimes. Moreover, the attorney's professional profile on Jeruchim and Davenport's website underscores her specialization in various legal domains, such as appeals, civil rights, criminal law, mental health, and personal injury. Furthermore, she was recognized as a top-rated criminal defense attorney, according to superlawyers.com. It's within this context that she initiated contact with me to understand my experiences. During our discussions, I recounted the series of grueling transports to and from the Plymouth County Jail leading up to my plea, detailing the distressing incident in which I was transported to court only to have the proceedings canceled and to be transferred to the Billerica County Jail, where I faced a confrontation with my wife's boyfriend, an employee at the facility who was also an alleged victim of the dismissed case. This encounter left me in a state of profound fear for my safety. I also shared how DeWitt had informed me that she had lobbied my case in my absence, and how she asserted that securing a trial date would necessitate another 6 months of waiting, thereby presenting me with the ultimatum of pleading guilty immediately. This option stood in stark contrast to returning to Billerica, where my safety was a growing concern, or to Plymouth, a place where I'd spent a harrowing year grappling with suicidal thoughts after being held on suicide watch. This situation encapsulates a stunning web of legal intricacies, ethical concerns, and personal struggles that we will explore in depth in this episode. For those viewers who have been following this channel from the beginning, meticulously reviewing the police reports, grand jury minutes, motions, and the intricate dance that unfolded during the lobby colloquy, waiver of rights, and the final sentencing, one thing becomes irrefutably clear. The indelible stain of fraud and deception isn't confined to the usual culprits, typically associated with law enforcement or prosecution. Instead, it has taken root within the very heart of the court system itself, and shockingly it finds an accomplice in the form of the attorney specially appointed to represent me, Debra DeWitt. This is a narrative that exposes a level of malfeasance and distortion that defies convention and elevates the egregiousness of this case to staggering heights. As we delve deeper into this episode, we'll continue to unveil the intricate layers of this legal labyrinth and the overwhelming impact it has had on me, on my life, and the pursuit of justice. As I transitioned back into life on the outside, I held on to the belief that the CPCS would be the beacon of truth and justice that would help me unravel the enigma of what transpired in that courtroom. Just 3 months after my release, my quest for the untarnished facts led me to reach out to CPCS, feeling resolute that they'd uncover the intricate web that ensnared me. During this time, I carefully adhered to the stringent probation conditions, not wanting to risk the possibility of returning to prison for another decade, even though I adamantly refused to pay any monthly or associated fees linked to my conviction, steadfast in my assertion of innocence. I was convinced that the wheels of justice would soon turn, setting the stage for a hearing and a Rule 30 motion for a new trial. But as this episode will reveal, this hope was naively placed. The inner workings of CPCS investigations remained a mystery to me, and after my ordeal, I couldn't even begin to speculate about their approach. Nevertheless, in May of 2016, the second attorney, Ann O'Reilly, reached out to me that she had been assigned to the case. Fast forward to July 2016, and Ann O'Reilly provided me with the transcripts of the colloquy of the lobby conference and sentencing. This was my first encounter with the shocking fraud and unethical behavior exhibited by my specially appointed counsel, Debra DeWitt, as I saw the evidence firsthand. As I delved into researching the Massachusetts sentencing guidelines, it became clear that DeWitt had taken it upon herself to assign a fabricated history category level for her client, an action that could only elevate the potential sentence from a false starting point. It also became glaringly evident that the judge had misled me about adhering to these guidelines, rendering my sentence disparate and at odds with their provisions. Slowly but surely, the pieces of the puzzle were falling into place, and I was awestruck by the gravity of the deceit that had transpired. I was convinced that with the CPCS investigation, answers and a prospect for a new trial were on the horizon, and it was merely a matter of time. During this period, I continued to labor in landscaping alongside the two other ex-convicts, and my growing paranoia amplified my concerns about the potential for being implicated in another crime akin to the situation with my own co-defendant, Ebby. The months continued to slip by with no word from CPCS, and by August of 2016, I had moved on from the landscaping job, haunted by the constant fear of a potential arrest associated with working there. I secured employment at the plastics factory down the street from my house, seeking some semblance of stability. During this period, Ann O'Reilly forwarded me a release form to authorize the acquisition of my criminal offender record information, or Corey report. I was aware that the minimus that had accompanied me to the prison from the court was a forgery, a fraudulent creation of the clerk of courts at the Lowell Superior Court, Michael Mahoney. However, to lay eyes on the Corey report firsthand was an experience that intensified my indignation and disbelief. It also exacerbated my existing anxieties and fears. The Corey report unveiled shocking revelation. The case originating in Wilmington had been null prost, effectively dismissed in the Woburn District Court. More bewildering still, the indictment had been erroneously documented as occurring in Wilbraham, a misleading classification that attempted to distance it from the truth, as if it weren't the same crime, all connected to the same case. Christmas arrived once again, bringing with it a mixture of joy and melancholy. I celebrated the holidays with my family at home, with the cozy crackling of the fireplace and the Christmas tree adorned with gifts beneath its branches. I prepared a hearty spoon roast dinner with all the classic trimmings. This was a bittersweet moment that would foreshadow the difficult times ahead. In the years to come, probation violations would loom over my life, constantly threatening to shatter the semblance of normality we'd managed to create. The specter of an additional 10 years hung over me, even in the face of the undeniable truth of the fraud that tainted my case and its proceedings. The new year, 2017, brought with it some developments regarding my case. Attorney Ann O'Reilly, who was conducting the investigation, had not yet provided any official findings. Instead, she decided to withdraw from the case, citing other commitments that required her attention. The screening of the case would now be handed over to a third, new attorney. Then in March of 2017, I received a letter from CPCS which contained attorney Aviva Jeruchim's findings. To my astonishment, she concluded that all of my claims were false. I'd like to read her findings for you. So the intake date was 3/28/2016, and this final conclusion came on March 20th, 2017, a year later. The determination was false. The basis is, I have reviewed Mr. Toppi's complaint, the materials that he submitted relative to his file, and his lengthy letter describing the emotional and physical difficulties as a result of his pretrial detention that he believes caused him to capitulate to a guilty plea, coupled with his belief that Attorney DeWitt was compelling him to take a plea. I have also spoken with Mr. Toppi at length regarding same. I have also reviewed Attorney DeWitt's file on Mr. Toppi and have spoken with her at length as well. I am finding the complaint false for the following reasons. I believe that Attorney DeWitt endeavored to get the best outcome for her client. The CPCS Assigned Counsel Manual Policies and Procedures, Section 4, Subsection 6 states that the attorney shall explain to the client those decisions that ultimately must be made by the client and the advantages and disadvantages inherent in these choices. These decisions are whether to plead guilty or not guilty and to change such plea, whether to be tried by a jury or a court, whether to testify at trial, whether to appeal, and whether to waive his or her right to a speedy trial. I believe that Attorney DeWitt did not necessarily violate her obligations in this regard and complied with the same. However, I feel that the delivery of this information to her client was unintentionally done in such a way as to cause Mr. Toppi to believe that Attorney DeWitt lacked confidence in trying his case. Whether or not a case is triable is a decision for the client to make, and regardless of whether it is or not, the attorney should be driving the decision, even if based upon the client's best interests. Attorney DeWitt herself conceded that she thought the evidence in the case was very challenging and, if tried, would have been ultimately heard before a very pro-prosecution judge who was very heavy-handed at sentencing. Although she believed that she was acting in the best interests of her client by steering him to the conclusion that a plea was in his best interests, her delivery of this information was done without the more appropriate neutrality that should have informed her client's decision regarding the outcome of his case. Unfortunately, this form of articulation is more common than not. I had a lengthy discussion with Attorney DeWitt about my findings, and she agreed that discussions with her client pursuant to the above-cited subsection should be addressed in a more neutral fashion and would be henceforth adopting this more nuanced approach. The shock of reading this determination from a highly regarded attorney, someone recognized as a super lawyer in Boston, left me with more questions than answers. After waiting for a year for the truth to emerge, I was left wondering how a legal professional of such stature could reach this conclusion in the face of all the irrefutable evidence on the record. If the evidence within the case documents clearly demonstrates fraudulent behavior, an attorney with expertise in the field reached a conclusion that contradicts these facts, it indeed raises concerns about the integrity of the legal process within the Massachusetts CPCS. In part 2 of this episode, we'll dive into the thorough examination conducted by my new investigating attorney. Despite high hopes for a fair assessment, her resulting 10-page conclusion reads more like a prosecutor's rebuttal. We'll explore this comprehensive analysis, addressing its key points and implications. As we dive deeper into Part 2 of CPCS investigation, the story of relentless fraud continues, weaving a dark web of injustice that spans years. We'll unravel the harrowing probation surrender hearings where the specter of 10 more years of prison loomed over me and the restitution hearing designed to silence my cries of innocence, unveiling the intricate machinations of Massachusetts criminal justice system. Until next time, I'm your host, William Toppi, reminding you that our pursuit of justice begins with you.